Mr. Buckner. Sir, I will give you an opportunity to address the court, but you're not going to interrupt You're not going to interrupt anybody. You're interrupted. State your name.
Lawrence Buckner.
All right. Go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Buckner.
All right. What are we doing on this case?
I have received all discovery and police reports with body camera. We're asking this matter to be set for exam. However, Mr. Buckner has, I believe, three witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that?
I don't object to the officer saying cover. We counsel is new in the case of where something lies earlier this week.
Sir, you need to face me.
We have
Sir, I will give you an opportunity to address the court, but you're not going to interrupt anybody. You're not going to interrupt anybody. You're interrupted. Yes.
This exam was held on Tuesday after the victim is testified, Buster Buckner, during a break in the exam, we did end up charging him threatening to injure a witness, and this is the victim that he was not contact as she was on the FA case. So in that sense, he had violated contract courts and also threatened from charges. So I was be asked to respond to him.
Sir, what did you want to tell me?
Sir.
Well, Mr. Buckner, I advise you don't make any mistakes.
Mr. Johnson, I need to speak because if I don't speak, this the prosecutor said they want to lock your man Judge Simpson. So I have sent my court. If I don't, I'm going to jail. Like I have family to support. Please. Like I am not guilty, and this is Tuesday. I had a hearing for a situation now. Right. During that hearing, it was my belief that the witness messed up his testimony. So it's being that I threatened her. I never threatened her. They said the officer has to fight her. No, that's that. You go fight him. I was talking to my family, my phone, and I was talking to them, and nothing I said, I'm going to threaten that lady, get that lady. They have been trying to harass me and my family ever since I got shot Father's Day, and I didn't cooperate with the police investigation. I got shot nine times in the head. 2 days before all these incidents, please hear me out. Deputy Caruso of Washington County kept my house saying, you need to testify on the shot. You need to testify on the shot. I said, Mr. Caruso, all I want to do is live my life. I got a family, I got my brothers here, I got a few people I don't like nobody get killed, but I died my brother. The next day, I got in an incident with my lady friend. It went from domestic violence to assault. This lady police officer Tyson came in, Washington County Jail. Got arrested, tried to read me a personal protection order. I said, I don't want to do it. I did wrong. Next day I woke up, I had stalking charge. That was dismissed. This is prosecution going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I go to court, and the prosecutor Judge Lorraine Washington is an eyewitness. This same prosecutor, I was in court on camera yesterday, sir. I was on court on camera, please hear me. Said Mr. Buckner, is threatening my witnesses in court. This is what this same prosecutor said. Judge Lorraine Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening.
So, hold on, stop. There was a video requested. Does the video show anything?
I didn't have a chance to discuss this morning. But we were talking immediately after the threat occurred, and she actually informed us that it happened. And then she did a police report, and then we authorized the charge.
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't know yet, just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
This was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday, and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always shown up to court. He's always shown up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Your Honor.
Yeah. Mr. Byrne, were you there on that? Well, they're asking for revocation of this bond because of the charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things. I don't know. There was a request made for video from this courtroom of that date. We got time narrowed down. You need to take your hands out of your pocket. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. We then, that was I think Byrne provided to the people in this case. They have not had an opportunity to view it.
So stands now.
Well, no, it's basically charged. It's authorized at this point. It's just it hasn't come through the system yet. Okay. So here's what I'm going to suggest, and may not like it, but I think maybe this is the way to do it. The video. Somebody from your office was handling his exam. Correct. Okay. He didn't see anything. So what I would do, and I get Mr. Johnson's point. He's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I don't know what's on video. I did not view it myself. And then have counsel look at the video. And then I will myself look at it when I get a break to be able to do so, and then make a determination if based upon that his bond in this case should be revoked. I think that's probably the fairest way that I can potentially. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. And I say this for that upon looking at the video, prosecutor said that someone court hearing. I physically said that I was ready to get this one.
Sir. First of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you saying anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point I'm going to keep you in custody. A video was requested. I'm going to give, the prosecutor's got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out preliminarily.
Judge Simpson. I'm very personal. I'm asking all aspects. I'm not like
Sir, I'm not saying that you are. Sir, I'm gonna expedite it as best I can to make sure that I can look at it, get you recalled back up and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it. But it affects his case. But the people that can look at it can do that. Maybe get in touch with Mr. Johnson. I don't know. But I'm just saying that's the way I'm going to handle it at this juncture. All right.
So the guy
Okay, look, Mr. Buckner, they'll be able to talk to you back there, but I'll pass the matter. Sir, you need to just quiet down, please. Where it does call the case of the people versus Lawrence Buckner.
Joseph McDonald, Your Honor.
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been. I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir. Lawrence Buckner.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness-intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir? And you understand also, sir, that executive sentence may be imposed for any other conviction. Do you understand that? Mr. Buckner, you can sit down while we go through this.
I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, give me for my motion. I don't know what to say right now, sir. I truly apologize.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are. Miss. He may be a bit.
See, I try to okay. And instead of video. That's what I understand. The whole basis reading today. Just video. And that's why I need help. I'm just trying to this. This is the charge of just watching work. Okay. Teach. I just from time. I apologize. Let's slow right now. So I apologize for the time. Y'all further ahead of me. Second, to try to stop these questions. Yeah. I understand, Judge. I'm sorry.
Okay, so you understand then the maximum penalties on that charge. All right. First question I have for you is, do you want to be represented by an attorney? On this, it's a public defender case. As to the formal reading, waive any further formal reading claims stand me. All right. Pleading not guilty, demanding probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
I'm not trying to stay in jail, Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
I don't want you to tell the judge, Johnson. Then I heard I could find out. I did nothing wrong. I need help. And help is not inside watching jail. Trying to testify. Like, I need help.
Okay, Mr. Buckner, based on my client's representations, I still ask the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So when we're setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
Say that's like 20 seconds.
All right. Well, all right. Right. But I think that will be before Judge Washington. All right. And on that case, his bond would continue. So on the other matter, I'll set preliminary examination. I hear what the defendant is saying. What date? April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
I would years ask that. I had a chance to look at what's available. What was done. They will be able
Thank you. Response.
Thank you, Your Honor. In this case, any context, just examine at time to testify by an exam. The defendant pointed a gun racked at her while she was working at a security guard. It was asked that the defendant to the bathroom, walking out in front of the alley. She immediately reported this significant intensive process return. Specific to the defendant lying, a line crossing victim getch. This is White House she testified being threatened to fire a best defendant. Based upon this defendant's conduct on a $100,000 bond, no 10% is appropriate in this case. This was very clearly an attempt by the defendant. They this witness our case condition of bond in that case number 5-121. I'm sorry, Mr. Was that he contacted the victim, and here it is in court threatening this stigma. This is not in place in a vacuum. This defendant has a misdemeanor domestic case. The FAA case that was subject to the exam firearm. And let's just felony case. Based upon this conduct, they've found an extensive history. They frankly have extreme public safety and safety. Whereas the addition of the bond in this case, they contact with the victim Hudson, have no explain that. And frankly, Your Honor, is this defendant's conduct brought us to this point. And the fact that this threat was uttered during a court proceeding, immediately after the testimony of the victim, is great for the attorney. And our line points to a significant bond. This is for the state of public against the state.
Yes, sir.
very clear something certain difference. Describe it as an outburst. That's surprise. Set angry outburst. They had try to charge. This something based on this context.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper conduct creation.
Certain sex shouldn't have outbursts. That's a violation. That's exactly that.
What is concerning in this case is that what is said, and I disagree with the defense that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with some respects with the underlying offense. What is said makes it even I will have to say more frightening if it was said. And that it is said during even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual. Is highly problematic and something this court cannot tolerate. should it be? That type of individual in this court's mind does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual who may be a danger. The court is going to set the defendant's monetary bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work. Once that's $75,000 on that case. Thank you.
Say the charge right now. Say the charge right now. Side of jail. So I asked Judge Washington to help me. They got me charged, Judge. And right? You may want to say, Judge Simpson, I'm charged with making a crime, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom.
Okay. And sir, this is the time that I got arrested and you standing here, the things that I was, I mean, the community of sir, and I know everything's here, I can make a decision, is that the video inside Judge Washington's court, Wayne Washington courtroom was the video that would prove my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped court immediately and said, no, he ain't looking at her, he ain't saying at her. He's mumbling things to me, trying to get my attention. This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Yes. Thank you.
No, but I can condition. All right. Thank you, Mr. Brown, and I appreciate that lesson on how to conduct a court. No, I appreciate. I always appreciate the help. No. Well, some places do it that way. I just let people talk. Okay, and you know that because you're still doing it. Okay. Have a good evening.